All right, Ms. Shaw, who do you have? All right,
Yeah, I don't know if it says Matthew Brown on your file or Christopher
it
Cameron.
has Christopher Cameron. And
Yes.
who is James Bolt? Because this was attached to this.
It has,
Oh, you're also James Bolt. All right, court is calling 2024 CR 012525, State of Texas versus Matthew Brown, AKA Christopher Floyd Cameron, AKA James Bolt. Can I have parties announced for the record?
Andrew Harrison, state.
Lindsay Shaw for Mr. Brown.
And are you Mr. Brown?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to your plea bargaining agreement, punishment is to be assessed at 2 years in the prison. There's a $2,000 fine. There are no applications. The state will take in consideration night mag number 745333 and 224 PF 09598. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State, any evidence?
Contained in Exhibit 1 and attachments, Judge.
No objection.
All right, state, you may be excused. Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Hey, Judge, he has been in the Bear County Jail for 232 days, so we're just asking that he receive.
All right. Court will follow your agreement. The court will find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. Take into consideration night mag number 745333, 2024 PF 09598. And the court will order the therapeutic community. It doesn't increase the time that you're in custody, but if you have a drug or alcohol issue, it will help you with that. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. How old are you?
43 years old, ma'am.
All right, so you're getting close to what I call the twilight of your life. And I can say that because I'm in the twilight of my life, unless I'm planning on living to be over 100, which we'll see what happens. But if you don't stop what you're doing, you're going to look up and find that you spent a majority in your life in custody. You understand?
Yes, ma'am.
If you have a drug or alcohol problem, once you're released, if you need help finding a place to help you maintain your sobriety, if I'm still here, you can come back and I'll help you get a place to stay, okay?
Thank you, ma'am.
All right, good luck to you.
Thank
And
you.
thank you for dressing appropriately for court. This was a nice trial outfit.
Yeah.
You all righty?
Thank you. Judge.
You're welcome.
Appreciate you. Have a good night.
Is Robert your client here?
Yes, I understand. Are we waiting to see what Alfonso is gonna do?
Oh, no, we can take your guy. He's ready for trial?
Ready? I need to make a record, Judge. Since
Sure.
The election is the jury for punishment, so I can make it with you present, and then we have some. I guess I need to know which case we're going on. So the
Number 8, second row. On the bench. Thank you. Next row. No, I got it. Row. All right, it's already so far. The numbers are on the seat now. Oh. Okay. And they're all in order. Thank you. And you need your number. Thank you.
All right, everyone, please be seated. Yes, I'll talk louder. All right, everyone, good afternoon. All right, this is the 187 District Court. You're on the 4th floor in the 187 District Court with Judge Boyd. So which floor are you on? What's the court number? Who's the judge? Now, you probably say, we already know where we are. We've been standing out in the hallway waiting upon you. The reason why I do that is because whenever we take a break, that means that you all have to leave the courtroom. And believe it or not, sometimes people get lost and we're looking for them and they are actually down the hallway trying to get on another jury. So if ever you're lost, if you remember 187, there's only one 187 District Court in Bexar County and in all of Texas. And there's only one Judge Boyd in the courthouse. So if you remember one of those two things, someone will be able to direct you where you need to go. This is a criminal court and we have no criminal cases. So in this courtroom, we have the state of Texas versus Mr. Raymond McKinney. I'm going to have the parties introduce themselves to you for the state.
Good afternoon, Megan Galloway.
Andrew Harris Edelman.
And for the defense,
Robert Mauer.
Trey Mauer.
Brandon McKinney.
all right. Now in your hands, you have very important items. They're cards. So if anyone has recognized any of those parties that have just introduced themselves to you, please raise your card. All right, number 30. Anyone else? All right, you can lower your card. The other thing, I have a court reporter to my left. The court reporter is taking down everything that everyone says. In order to make her job easy, I need all of you to speak at the level and tone that I'm speaking at and at the pace that I'm speaking at. because she has to write down everything that everyone is saying. Does everyone understand?
Yes.
Whenever you want to speak or address an issue, you need to raise your card and wait until someone acknowledges you. The way I acknowledged juror number 30, you need to wait till you're acknowledged and then you can speak. It is best that everyone speak one person at a time to make it easier for her. Does everyone understand?
Yes.
Now, I'm going to do something. Every jury has failed at this task, but I'm going to tell you what I've told every jury, and we're usually in jury trial every week. So you do the math. I want all of you to raise your cards. And when I tell you to lower your card, lower your card. Jurors 1 through 21, please lower your cards. Everyone else, if your card is still being held high, whenever you speak, I'm going to need you to stand because the acoustics in this courtroom is not great. And if you stand when you're speaking, the court reporter will be able to hear you. Can everyone do that?
Yes.
I'm going to tell you what I told other jurors before. I have faith that you're going to do that. So hopefully that will happen this time. And if it does, this will be the first time that it has ever happened. All right, you can lower your cards. So juror number 30, you said you know someone. Who do you know?
Me and Mr. Maurer went to high school together.
All right.
That is correct.
So tell us, what were his grades like?
Student, also a great athlete.
All right, thank you. All right, so as I told you before, this is a criminal court and we hear criminal cases. So in this courtroom, people are accused of offenses, and that means just accused. It doesn't mean that someone is guilty or not guilty. It's just that they've been accused of an offense, and jurors are selected so jurors can hear evidence and make a decision on whether or not someone's guilty or not guilty if they're able to make a decision. Does everyone understand?
Yeah.
So in this case, Mr. McKinney stands charged with 2 counts. Count 1 is possession with the intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. Count 2 is possession of a controlled substance, penalty group 1, 1B, 4 to 200 grams. Now, when I speak to you and when the state and the defense speak to you, they're not allowed to tell you what they think the facts are in this case. So whenever they speak to you, they're going to be talking about hypotheticals. So do not go in your mind like Mrs. Kravitz from Bewitched and say, oh, then this person did this or that person did that. They are just speaking hypothetically. The only way you will be able to hear what parties think the facts are in this case is if you're on the jury trial. Does everyone understand?
Yes.
All right, let's talk about an indictment and what an indictment means. An indictment is just a piece of paper. That's all it is. It's a piece of paper that is used to bring people to a criminal felony court to answer for what they're being accused of. It's not evidence of guilt. It's not evidence of anything. It's just a piece of paper to tell somebody, this is what you're charged with. This is where you need to be. Does everyone understand?
Yes.
All right. Raise your card if you have ever had a traffic ticket before. Now, what I will tell you, that trend still continues. It appears we have some of the worst drivers in San Antonio. I will tell you, I've had a traffic ticket before too. You can lower your hand. So when I got my first traffic ticket, I've only had one. It was back in the day where the officer had a paper booklet and had the carbon copy, and he tears off a tag or she tears off a tag and she gives you this sheet of paper. On that sheet of paper, it will tell you what the officer is saying they're saying you did. For example, hypothetically, let's say running a stop sign. So you get a ticket. The officer says you ran a stop sign. You accept the ticket. Your accepting of that ticket is not saying, hey, officer, you're correct. I ran a stop sign. It's just to let you know, this is what you're being accused of, and this is where you can go for a jury trial if you want a jury trial. And usually in San Antonio. That's the municipal court on Frio. So that traffic ticket is not evidence of guilt the same way an indictment is not evidence of anything. It's just a piece of paper. Because can you imagine if nobody gave you a piece of paper and it just said, see you in felony court or see you in municipal court. And when you get there, you'll know what you're being accused of. That wouldn't be fair. So that's all that is a piece of paper. You cannot consider it as anything. Is there anyone here who cannot do that? All right, the next thing I want to talk to you is certain rights that anybody who's accused of an offense has. Everyone has a right to remain silent. What does that mean? That means that you don't have to testify if you don't want to testify. I've been a defense attorney, I've been a prosecutor. Sometimes you have a client as a defense attorney and you say, state didn't prove anything. You don't need to testify. Sometimes you have a client who has a speech impediment or who's extremely shy or who is extremely nervous, and you think it may be in his best interest not to testify. You have a discussion with your client and your client's like, yeah, you're right, I probably shouldn't testify. The main thing I want you to take away from that is everyone who's charged with an offense has a right to remain silent, a right not to testify. And I've had some jurors tell me this, well, if it were me, I would take the stand. And I always tell jurors and I tell my family members, that's easy for you to say because it's not you. So you're not allowed to hold it against someone if they decide not to testify. Is there anyone here who will hold it against Mr. McKinney if he decides not to testify? All right, the next thing I want to talk to you is presumption of innocence. When someone is accused of a crime, they are presumed to be innocent. What does that mean? That means that you come with a cloak of innocence surrounding you. So when you come to court, unless and until the state presents you with evidence that proves someone who's accused committed a crime beyond a reasonable doubt, that presumption of innocence is enough to find them not guilty. Now, notice I said the state has to prove. So that means that the defense does not have to do anything. When we were in law school, our professors told us, so really what that means, you can sit over there, play board games, you can play chutes and ladders, you can play whatever, you can go to sleep. And the reason why our professors told us that is because they really wanted us to understand that as someone who's accused of an offense, you don't have to prove or do anything. Does everyone understand? Now, if you had to vote right now on whether Mr. McKinney is guilty or not guilty, what should your vote be at this point in time? I'm sorry, I can't hear you. All right. So the state has the burden of proof. What is their burden of proof? Their burden of proof is proof beyond a reasonable doubt. I know your next question. Well, what's the definition of that? There used to be a definition. When we were in law school, we had to memorize that definition. I knew it forwards and backwards. However, the law changed. There is no definition for proof beyond a reasonable doubt. So when I was a practicing attorney, I said, how am I going to explain this to the jury? Because we don't have a definition. I said, let me explain it to them by telling them what it's not. Next door, the building with the green rooftop, they try civil cases. One burden of proof they have is preponderance of the evidence. It's more likely something happened than not. That is not the burden in criminal cases. So if you're ever on a jury and you're deliberating and you're back there and you're saying, you know what, I believe this happened more likely than not, you have lowered the burden. You are not at the proper burden. Does everyone understand?
Yes.
The other burden they have next door is, and it's their highest burden, is what's called clear and convincing evidence. Clear and convincing evidence is the evidence that they use for the government to say, you are not a good parent, you're a danger to your child, so we're going to take away your rights to be this child's parent. I think everybody would agree that's a very high burden. Guess what? There's a burden that's higher than that, and that burden is proof beyond a reasonable doubt. Does everyone understand? The next thing I want to talk to you about is fairness. And what does fairness mean? Sometimes people will give you this hypothetical. So I'm going to give you this hypothetical. I know all of you were excited to come for jury duty. So you planned it out the day before. You planned the route you were going to take. You knew how to get here. And let's say you made your plans. You're excited. You're telling everybody, I'm going to do my civic duty. I'm going into jury duty. You get up, you get ready, you come downstairs, go out your door, and your car is on cinder blocks. Somebody's stolen the tires. They just stripped your vehicle. But you're like, I'm a good citizen. I've called the police. That's been reported. I am still going in to do my jury duty. So you take the Via or a Lyft or an Uber, you get down here, and then you get called up to court. And the case you're called on is for a burglary of a vehicle. All right, so let that marinate. And then people will ask you, so that's really not the case for you. You really couldn't be fair in that case, could you? This is what I tell everybody. The question is whether or not you would be able to sit on that type of jury, knowing that your car has just been burglarized, and listen to the evidence that's presented to you. And if you can come to a decision, you'll base that decision on the facts of that specific case. So nobody was born yesterday and slept all last night. Everybody has different issues that have happened to them in their life. The only question is whether or not you, if you were selected for a jury, would you be able to sit on that jury and base your decision, if you're able to reach one, on the facts that are presented to you? Now, I've told you this is a drug case. Is there anyone here, if you were selected for the jury, that could not be fair based upon everything that I've just told you? Okay. All right. The next thing I want to talk to you is there are two phases to a jury trial in Texas. First phase is whether you find somebody guilty or not guilty, if you can come to a decision. People are confused. Sometimes they think that's the innocence phase, but it's really not. The first phase is, did the state prove their case or did they not prove their case? If you determine that the state didn't prove their case, that means not guilty. If you determine that they did prove their case, then that means it's guilty, in which case there's a phase 2 of the trial. And phase 2 is what's called the punishment phase. And that's where you decide what the appropriate punishment would be. Does everyone understand?
Yes.
Anyone who's charged with a criminal case must make a decision before jury selection that if they were found guilty, who would they go to for punishment? They have to make an election. In this case, Mr. McKinney has said if he were found guilty, he would let the jury decide his punishment. Is there anyone who's going to hold it against Mr. McKinney because he's made that selection? Now, the next thing I want to talk to you is about ranges of punishment. Count 1, possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. The range of punishment for that offense is anywhere from 5 to 99 years or life in prison. Sometimes the range of punishment can also be anywhere from 15 to 99 years or life in prison. So what does that mean? That means with that type of charge, 5, 6, 7, 8, 9, 10, 11, 12, all the way up to life, or either 15, 16, 17, 18, all the way up to life. That's a wide range of punishment. Count 2, possession, penalty group 1, 1B, 4 to 200 grams. That range of punishment can be anywhere from 2 to 20 years. So that's 2, 3, 4, all the way up to 20. It can also be 5, 6, 7, 8, all the way up to life. Does everyone understand the full range of punishment?
Yes.
Now, sometimes people will say, you know what? It's a drug case. I don't think any of those punishments are appropriate for a drug case. That's the law. Does everyone understand? I'm telling you what the law is.
Yes.
Is there anyone here who cannot follow the law with regards to ranges of punishment? You need to raise your card. 57. Thank you. You can lower your card. All right, the next thing I want to talk to you about is languages. I love languages. I'm originally from Louisiana, so of course I took the language that I should have taken, which was French. I didn't think I would be in San Antonio, but lo and behold, I'm here and I should have listened to my friend in junior high and taken Spanish, but I didn't. So how many people English is not your first language? Please raise your card. We have 6, 12, 44, 48, 60, 65, and 66. Juror number 6, have you been able to understand everything?
Yes.
12, same question. 44, same question. See, you didn't stand.
Yes.
All right, I'm gonna start over with y'all. Number 48,
Yes.
thank you. 60,
Yes.
65,
Yes.
thank you. 66.
Yeah.
All right, see, y'all not standing. Okay, we're gonna start over. Make sure you stand, guys. All right. Is there anyone who has any time constraints from speaking to both parties? I expect this jury trial to probably last through Thursday, probably at the latest Friday. Is there anyone who has any type of time constraints? Raise your card. 1, 3, 5. Oh, just have a seat. You don't have to, just raise your card. Number 1, what's your time constraint? How old is the child? And who is with them now? All right, thank you. Number 3? All right, thank you. And everyone, keep your cards up until I tell you the lower. Number 5.
I have a mediation Thursday morning.
All right. Number 7.
I'm a teacher and I have art meetings, legal meetings with special education students, families that I need to do.
All right, thank you. Number 8. Number 9. All right, and what sport? All right, and how are they doing? How are they doing? All right, what's your definition of great? I like your answer. All right, thank you. Number 13.
My wife is getting surgery on Thursday morning and I have to ride and there and back, so.
All right, thank you. 17.
I have 2 issues. One is clients coming in for, as a real estate broker for an estate that's being settled, and I don't know the exact time schedule this week. And the second is a very close friend that's dependent upon me as their caretaker, that's being dismissed from hospital on Thursday.
All right, thank you. 18.
I'm currently on vacation. I go back tomorrow.
Okay. Number 19.
I have 2 doctor's appointments tomorrow afternoon.
Number 24.
I have scheduled meetings and we have an audit coming up.
All right, thank you. Number 26.
My oldest daughter's pregnant and is gonna have a baby in the next couple of days.
Are you going to participate or are you going to pass out? You're not going to pass out?
No,
All right, when is this? When?
next couple of days.
All right, thank you. 28.
I have a doctor's appointment on Thursday. Also childcare. My kid's father leaves today.
All right, thank you. 29.
Just a single mom, childcare issues as well.
How old is your child?
Well, getting off the bus being by himself.
All right, what time do you do pick up?
3:50, or he gets off at 3:30.
All right, thank you. 30.
I'll be busy with workman's.
All right, 31.
I'm a high school orchestra teacher and we have a competition on Monday and Tuesday.
All right, thank you. 37.
Meetings at work, and I have supplier business on Thursday.
All right, thank you. 38,
I'm usually relied upon for my job to assist the manager with opening the store, and currently my schedule is to work on Thursday to assist her, and our district manager will be the same.
all right, thank you. 40,
I'm a home health skill visit nurse, and my patients rely on me all the time. I'm also on call and I have no backup at this time.
all right, thank you. 41,
I'm expected to be at work the rest of the week and I have to drop off and pick up my kids from school and out.
all right, thank you. 48,
My mom has surgery on Thursday at 6 o'clock, so I have to take her at 6 o'clock and be there with her. And then on Friday, I have a doctor's appointment.
all right, thank you. 49,
Doctor's appointment on Friday morning and then a job interview.
thank you. 51,
Got scheduled meetings at work.
all right,
Meetings with corporate.
all right, 53,
I actually work overnight and I've been on vacation on Thursday.
all right, thank you. 56,
I do have several meetings at work, and I currently
all right, 60,
I'm in a meetings in my work.
I'm sorry, what?
I have meetings at work.
All right, thank you. 58,
Well, my two kids have appointments on Thursday.
57,
my dog depend on me. I got a blind one and I got one that the bone is showing, and they need to in and out of the house, and they bark in the back and they'll call the cops on me. And
all right, thank you. 62,
I supervise ophthalmology residents at University Hospital, but it's just Thursday and Friday.
all right, thank you. 64,
I'm a small business owner and I do not have anyone to help me with the shop.
all right, 66,
On Thursday and Friday, I have an appointment of the doctor.
all right, thank you. 67,
On Thursday and Friday, I head back to work those days.
all right, thank you. 69,
I go to work on Wednesday and then I have school all throughout the,
and your school, is that in person?
yes.
All right, thank you. 71,
I have to give a departmental report on Thursday morning.
all right, 74,
I work in the morning, Thursday to Friday, all the way to Monday.
all right. All right, thank you. All right, ladies and gentlemen, I'm gonna tell you two stories. Both of them are true. I always tell people that jury duty is an inconvenience, not a sacrifice. I know sometimes people think it's a sacrifice because you hurry up and you have to hurry up and wait. You don't know where it is. They make you pay for parking. But what I will tell you this, excuse me, may I help you? Step outside. Yes. All right. So what I will tell you is that these are inconveniences. Your country only asks two things for you. The only two things they ask for you is one, to pay your taxes and come and serve on a jury. Raise your card if you've ever sat through an entire jury trial as a juror. If you'll see, that's not even half, that's not even a third, that's not even a tenth of the jurors that are here. You can lower your card. So what I always tell people, this is sacrifice. My family grew up in a small town called Grand Cane, Louisiana. My uncle was super intelligent. They just kept passing him from grade to grade. When his sisters came behind him and his brother came behind him, they were upset. And the reason why they were upset was because he was super intelligent. So the teacher said, we're going to be expecting a lot out of you. He ends up graduating. He graduates early. When he graduates, the Vietnam War breaks out. And he goes to my grandmother, and he's the firstborn, and he asks for her to sign for him so that he can go fight off in the war, because he says, with civil rights, there is no way I'm going to improve my lot in life here. So she signs for him, and she sends her firstborn off to war. And for the young people, this wasn't where you have 24 news cycle. You're able to take photos of food with your phone. That wasn't that era. In that era, you only had three stations, ABC, NBC, and CBS. NBC really wasn't stationed because the weather would have to be perfect for you to get information. And then this whole news cycle where you all see 24/7, you can watch television, you have all these channels. No, it wasn't 24/7. When they were done with programming, they would play the national anthem and you wouldn't get television back till the next day. This whole computer thing where, oh, let me just shoot an email, they didn't have it. The phone, I know young people don't know what a touch tone is or a rotary, but my grandmother didn't have a touch tone or a rotary. You had the phones where you pick it up and operator answers, and then you tell them who you wanted. That's why they would have songs like Beechwood 45789, because you would tell them this is who you want. All my grandmother had, of course, was her firstborn's name and the number that she puts on the envelope, and it says Vietnam. That's where you send it, and you wait for the letter to come back, arriving like maybe 6 months later. My grandmother only had a 6th grade education, but she was super intelligent. When she babysat me, she taught me how to read, tell time, everything. And of course, life lessons. One thing she quickly realized is that you do not want someone in uniform knocking on your door, because that was not good news. So I tell people that's a sacrifice. So when people try not to do jury duty, but then when it's Memorial Day, people are waving their flags, or it's 4th of July and they're waving their flags, I always tell them, this is an inconvenience, and this is what your country is asking you of you. Country not even asking you to go to war because they don't have the draft anymore. They're just asking you to devote a little bit of your time to be on a jury. And if you're selected on a jury, what I can tell you is Mr. McKinney, the defense attorneys, the state's attorneys, they want someone to be focused and to listen, because both sides want a fair trial. And for the state, for the defense, for Mr. McKinney, this is extremely important to them. And it's the most important time of their life right here and now. So I'm going to turn it over to the state and defense. They're going to ask you some questions. They each going to have 15 minutes. That's what they agreed on to speak to you. So answer all of their questions. I know you all will. All right, state, I'll turn it over to you.
Thanks, Judge. Did you let me know when I have 2 minutes?
Yes.
We attorneys have a saying, if you talk, you walk. I'm gonna give you a concrete example. The last jury trial that Galloway and I had together, there was a guy who didn't say anything during the entire voir dire process. And he ended up on the jury. And when he learned that he was going to be on the jury, he was visibly annoyed. Moreover, as the trial went on, we found him occasionally falling asleep during testimony. The British have an expression, it's not a good look. So, if you talk, you walk. The people who speak up, you give us more information about you, potential reasons why you should not be on a jury. If you keep silent, we have no reason to remove you. So, don't be that guy. If you have something to say, say it. We're not going to take it personally. Now, the judge already read out the elements of the offenses that the state alleges. They're alleged in the indictment. Possession with intent to deliver and possession of a controlled substance. So let's start with the mental states, intent and knowledge. Those are defined in our penal codes. A person acts intentionally when it is his conscious objective or desire to engage in the conduct or cause the result. 21, what does that mean to you?
Could you repeat the questions?
Sure. The mental state of intent means when it is a conscious objective or desire to engage in the conduct or cause the result. What does that mean to you? And Stan? That's fair. Have a seat. Could you repeat what you said, please?
I would need some time to look at what it is more.
Got it?
Understand the question.
17, what does intent mean to you?
Intent means that you're willing and you're conscious of what you're doing in your actions.
32, stand up. Do you agree with 17?
Yes.
Why?
Within your mind, you're able to make a decision and you're of sound mind and body to be able to make that decision.
49. Do you agree with 17 and what was your number? 32. Do you agree with them? Why? All right. Is there anybody who disagrees? What's your number?
31.
And would you stand up? And could you briefly explain why you disagree?
Yeah, sometimes you intend on doing something and the result isn't the way you planned it or intended the result to be. An intention can not always lead to a result or desired effect that you're.
Did everybody hear 31? Is there anybody who agrees with 31? 7, 19, 20. If you agree, just raise your card. 2, 5, 11, 12, 7, 15. And when I say your card number, you can put it down. 19 through 21, 33, 36, 34, 35, 37, 38, 41, 52, 53, 57, 58, 69, 71, 72, and 75. Thank you. Now, there are two mental states for these offenses. One is intent. The other is knowledge. A person acts knowingly when they are aware of their conduct and know it is reasonably certain to cause the result. 12. Juror number 12. Which one are you? Yeah, stand up. What does that mean to you?
Could you please repeat that?
Sure. A person acts knowingly when they are aware of their conduct and know it is reasonably certain to cause the result. What does that mean to you?
The person knows what they were getting themselves into, which also has to do with their knowledge of situation.
Pretty good. Have a seat. Number 8. I thought I saw you raise your hand. Is that right? Please do.
Yeah, first they gotta know what they're doing. Have to know what they're doing. They intend not have, they have reasonable expectations.
All right. Thank you very much. By the way, there's one thing that I forgot to mention. If I ask you a question and your answer is I don't know, that is a fair answer. Just say I don't know. You're not going to get upset. So, number 27. How do we know someone's mental state? Give me some examples.
The way they stand, the way they talk, the way they look.
Okay, have a seat. 37, stand up. Do you agree with 27? Please elaborate.
Guess with somehow how somebody responds to different things, how their reactions to different situations, whether it's small or big circumstances.
49.
I would say we don't know somebody.
Sorry, what is, can you repeat that louder, please?
I believe we just don't know somebody. It can be a little clear, but.
Fair enough. 65.
I do agree with that response.
With 49's response? All right. Who else? You stand up. 55. And you can have a seat now. Who agrees with 49? Raise your card. 2 through 5, 7, 9 through 12, 14, 15, 19 and 20, 22 through 26, 28 and 28 through 30, 33, 35, 38 through 43, 44 through 40, 44 through 50, 51 through 54, 56, 57 through 60, 61 and 62, 64 through 68, 69 through 75. So all of the people who agree with 49, and I'm going to single out 16. I'm sorry, you didn't agree with me. Let's see. Who agreed with 49? 5.
Well, it's
Do you-
very, oh, I'm sorry, go ahead.
No, I apologize for
Okay.
interrupting. Do you think it's impossible to know someone's mental state?
And maybe not impossible, but it's very difficult. I think it's a subjective thing.
Okay, who else? 59.
Yes, I don't think it's possible to judge someone's mental state because it changes every day, every hour.
All right. Anyone 22?
I think it's probably, I feel like you have to know that person or know the background of that person to be able to understand.
Thank you. 51.
Legalese interpretation of minds.
71.
It's just hard to know someone's mental state, just because that's what they're doing doesn't mean that's drawing.
All right. Thank you, everyone. 7, do you want to say something?
I just absolutely think it's impossible to know somebody's true mental state. People hide things all the time, and when violent crimes happen, there's always people that come out that were very close to them that were like, we had no idea this was going on. Someone commits suicide, you had no idea that they were in that place, even if you're close to them. So I don't think that you can truly 100% know somebody's mental state.
Thank you. 38.
Thank you. I just want to say that I concur with the previous statement. We are not that person. I was always told growing up, you are not aware of everybody's truest intentions because you are not that person. You do not have the same mindset as them. Therefore, you can only surely your own mental state.
All right. Thank you. 17.
I concur with the young lady in front of me who's a teacher. She sees this at all times. The individual that I have to visit in the hospital, I saw him yesterday. They had a psychiatrist come in. They have professionals that come in and assess people's mental state. Where are we to use an emotional, personal judgment to determine someone's mental state?
All right.
5 minutes.
Thank you. Now, let's talk about possession. 14. Stand up. Got anything in your pockets?
Sure.
I'm not going to ask what it is, but whatever you have in your pockets, do you possess it?
Yes, sir.
How?
It's my personal property.
It's your personal property. Are you exercising control over it?
Yes, sir.
Okay, have a seat. 53. 53, stand up. What about you? Got anything in your pockets? Some lint? Are you exercising care, custody, and control of your lint? Fair enough. So the point that I'm making is that we judge possession not on the basis of whether somebody owns something, but on whether they exercise what we call care, custody, and control over it. Now, the state should prosecute drug offenses. I'm going to ask a 4-part question. Number 1, strongly disagree. The state should not prosecute drug offenses. Who agrees? Raise your hand. 57. Anybody else? All right, thank you. Just disagree. Don't have particularly strong feelings, but it's not something the state should do. All right. Should prosecute drug offenses. Agree. 1 through, okay.
Doesn't put your cards down.
Yeah, I apologize. So, what's your number? Stand up. What is evidence? What kind of evidence would you expect to see in a trial?
The truth. That's the best way I can answer that, I'm sorry.
That's fine. 43.
Big efforts to gather evidence.
Okay, what about you, 44? 42, my apologies.
Whatever he was in possession of, or she.
Okay, so physical evidence, the actual object itself, that would be evidence, right? What about someone's testimony about what happened? Is that evidence? What about, you're shaking your head
Oh, I
no.
will see.
60, you don't think,
Well, the testimony is what you say, but it's not something that you can show people.
thank you, 65.
Evidence is, testimony is a hearsay, so it's not something that is true necessarily.
What is your number, sir?
65.
Thank
Is there anybody who agrees with 65? 1, 12, 7, 22, 28 and 29, 30 through 34, 40, 49, 51 through 53, 56, 58 and 59, 64, 67, 68, 71, 72, 74. Now, how many of you have had an interaction with a law enforcement officer that left you distrusting law enforcement in general? 50, stand up. Could you briefly describe what that interaction was?
I was shot into 18 and nothing was done about it.
You were shot?
8 to 13 times. Nothing was done about
Shot by a police
it.
officer?
By a random person.
Okay, thank you.
I'm sorry, what is your number again? Thank you.
So I'm asking about interactions with law enforcement officers that led you to distrust the law enforcement officers.
All
I
right, you have
appreciate
20
you.
seconds.
Sorry, Judge?
20 seconds.
71.
Was almost run off the road by a police officer and he gave me a ticket.
Is there anyone who's had an interaction similar to 71? All right, thank you for your time.
All right, defense, yes.
This is kind of like the, what do they call it, the speed round. So if anybody here hasn't answered any questions, and you want to say something, volunteer, because I had a guy show up on it, we put him on a panel one time, and because he didn't answer any questions, and his mom came looking for him because he was mentally disabled and he'd snuck out of the house when he got his jury summons. So we sat through a trial for 2 days before realizing that he wasn't capable of speaking. So if there's something you want to say, something that's important, volunteer, because like Andrew said, the people who end up on the panel are the people who don't say anything, right? So we need an opinion to judge whether or not you're the right kind of person for this case. So has anybody here had either themselves or a family member who's been affected by drugs or addiction to narcotics? Okay. 2, 8, 4, 11, 6, 7, 16, 17, I got it. Thank you. 19, 20, 21, 22 through 25, 27, 28, 31 through 33, 36, 37 through 43, 44, 46, 49, 50, 51, 53, 56, 59, 58, 57, 62, 64, 65, 67, 68, 72, and 71. Okay, of those people who answered that it had affected them, who here feels that effect, that problem that either themselves or a family member had, would that make it so you couldn't be fair and impartial on a case like the judge told you involves allegations about drugs? Can you raise your card? Okay. Number 2, number 11, number 20, number 28, number 32, number 33, number 42, 38, 57, 62, 67, 71, and 72. And Judge, I said we have 50 minutes. Can we do these on? Will we bring them up?
Yes.
Okay. So you were asked about interaction with police officers, right? I know some people here who are prior law enforcement. It used to be really common, not so much nowadays. Who here would, if a police officer testified, give their testimony more credibility than an average person just because they were a police officer? It's kind of like the old Mayberry days, right? Everyone, if a cop testified, you believe him because we all kind of assumed they were infallible, right? It's not as, there's a lot more TV, a lot more access, but who here, and listen, nobody's going to judge you on it. We just need to know if you're the right kind of person. Who here would give the testimony of a police officer more credibility just because they're a cop? Number 5, number 14, number 20, 22, 23, 24, 30, 31, 33, 40, 45, 51, 62, and 63. Who here has heard the phrase, they got off on a technicality? It's like on the TV shows, right? Who here watches like crime dramas? Okay, I do too. Actually. So who here has heard the phrase, they got off on a technicality? Right? Juror number 59. What do you think a technicality is?
Something where they can not prove it, but maybe, oh, they ran out of time or they didn't collect the correct evidence.
The law,
The law.
right?
Yeah.
So when people say getting off on a technicality, very often it means the law says there are certain ways you're supposed to proceed. And if you don't follow the law the right way, the case gets tossed, right?
Correct.
Okay, thank you. So the law allows a jury, if they feel evidence has been obtained illegally outside legal procedures, to exclude and disregard evidence. Okay? What that does is give a jury the same power as a judge to say, hey, this wasn't done right. You didn't follow the Constitution, so we're not going to consider anything that was seized illegal. Okay, everyone understand that?
Yes.
Right. Who here believes that they couldn't do that? Who here thinks, and I'm going to give you the hypothetical where you listen to evidence, okay, and you tell yourself this wasn't done right. The officers didn't follow the law. They didn't follow the proper procedure. Knowing that, who here said, yeah, I can't disregard that evidence. I'm gonna let it in any way, even if I think that the officers acted improperly. Okay. Right? Are you raising your card?
I was thinking about it. I don't know.
You have a question?
No, I'm not sure.
Okay.
To be honest.
So number 7,
7.
number 30, number 38, you have something you want to say?
I just had a question.
Sure.
Were you referring to, and I'm sorry, I'm a bit mentally slow, so.
That's okay.
But were you referring to saying that despite the evidence, like people believe that you cannot trust law enforcement?
No.
Sorry, I misunderstood.
What I'm saying is, if you're on a jury, you get to decide whether or not you think evidence is admissible. Okay? So, if you listen to evidence and you know, it's something the judge talks about as far as a jury charge, you can make a decision as a juror whether or not you believe evidence was obtained illegally. And if it was obtained illegally, you can disregard it. Okay? So anybody else feel they couldn't do that? You want to raise your cards again so we can go through it? Number 6, number 7, 22, 28, 30, 40, 57, and 67. So let's talk about the purpose of the justice system. Okay. Who here thinks the justice system is meant for rehabilitation? To take people who have made mistakes and help counsel them and make them better? Who here feels that's the ultimate purpose of the criminal justice system, depending on the case? Number 5, number 14, number 33, 40, 59, 57, 61, and 69. Okay. Who here feels the justice system should be about punishment?
Should be or is about punishment.
Either one. What do you want to say?
I feel like it should be about correction, I mean, about rehabilitation,
Mhm.
but it is more about punishment.
I think it'd be both, punishment and
That's fair.
rehab. Get punished and then get rehabbed while you're
Okay,
being
well,
punished.
let's ask this. Who here thinks it should be about both? Okay, so I'd say everyone except for number 8, right? You number 8? Okay. So who here feels that it should just be about punishment? That's, don't worry about rehabilitation. It should all be about punishment, you know, but it's eye for an eye, tooth for a tooth kind of thought. Anybody feel that way? Number 20? Okay.
What was
That-
your number?
Number 41. And that's why the judge talks about the range of punishment, right? Because that range of punishment gives you some leeway as far as, you know, taking into consideration different factors, right? Number 47 and number 1 and number 8. Okay. Now. So the judge talked about, I think I'm actually slightly older than she is, but
4 minutes.
thank you, Judge. We used to have this really great definition of beyond a reasonable doubt, but the legislature in its infinite wisdom took that away. So you determine in your own mind what you think is beyond a reasonable doubt, okay? So clear and convincing, I think, is the burden to take away somebody's kids on the civil side. So imagine how much higher the burden is on beyond a reasonable doubt. It's not beyond all doubt, but it's got to beyond a reasonable doubt, okay? Who here disagrees with that burden? They think it should be easier to convict somebody. Anybody? Okay, so I've got 3 minutes left. Who here has not answered a question? Okay. Somebody want to volunteer? Because you're in the splash zone, as we like to call it. Number 25.
Sorry, when you mean answer, just raise my card at one point? If I did raise my card.
Okay. Anything you want to tell us about why you'd be or wouldn't be a good juror on this case?
No, I don't have anything to add. I mean, I'm fair with my kids, so.
Boy, that's tough.
That is.
Yeah. That's my son, so. Anybody else who, number 47, what do you want to tell us?
With the criminal justice system, that your last question that you had, whether or not the responsibility is to rehabilitation. I think there are other apparatuses in society that can handle that. So I think as it is today, it is private funding.
Okay, all right, thank you. Number 73.
It's like I've seen courts and stuff and I've seen judges or heard of judges
like try to rehabilitate people for whatever, different circumstances, and I also believe that, sometimes you need to take the punishment for what you did, but I also feel like people can be and
Rehabilitated.
rehabilitation.
You think it's maybe a case by case basis?
I think so.
Okay. Anybody else who wants to speak? I think we have your opinion about everything now. Yes, number 38.
Last thing I would like to add, my belief is that personally, that there should be more so geared towards rehabilitation when it comes to the justice system. But currently, I feel like there's a lot of corruption when it comes to our justice system. And I personally have a lot of distrust. That's just me, from the way how I grew up and from what I was told by people I was closest to.
Okay, thank you. Anybody else? All right, thank you all.
All right, ladies and gentlemen, I'm going to have you all wait outside. You're not excused. Leave your numbers behind, and we will call you back in shortly. Everyone, please rise for the jurors.
Don't take the number.